So, with that all said, what I am going to do now is introduce the host of today's session. This is Marita from over at Lang Management. Marita, take it away, my friend.
Thanks so much. And Jeff, I so appreciate you and Danielle being here today. We went to Kay Bender and Rembaum because we've been doing the Association Matters, which I
Right.
hope some of you have attended. We'll be sending those out to you for up and coming sessions. But we're really trying to keep the board members educated, and with the managers, those that we can offer for CEUs. But we
Right.
want to make sure education is power for you as a board member, that you really know what's going on in your community and you know it firsthand. So I appreciate you offering these. I know there are other attorneys that are offering them, but you have to be a client of them, or there's charges for the classes. And Kay Bender and Rembaum is doing these free of charge and to people who are not their clients. So it was a win-win for us on all sides, for
Ah,
those
well,
of
thank
you
you.
who either are Lang clients or aren't Lang clients now. We appreciate that you're doing that because there's a concern amongst the board members that they want to have this continuing education. And I want to make sure, and I know you'll probably mention it later on again, Jeff, but
Yeah.
there is also a seminar at 2 o'clock today,
Right.
which is two other CEU credits. For those of you who may not be aware of that, there's one this morning and then there's another one this afternoon. So we really appreciate you doing this. And, Danielle, you taking time out of your day to do this. We work very well on many of our associations with Kate Bender and Rembaum. And if you are looking, to make a change or not happy with the attorney you're with, they are very responsive to us and to our boards, and we appreciate the support that they give us for our board members and for the education. So thank you guys. With that, Danielle, I'm going to turn it over to you to take it away.
Thank you.
Thanks so much, Marita. Thank you, thank you. Um, like Marita was saying, uh, education certainly is paramount. And if you are joining us today for the morning and for the afternoon, you can get all four of your continuing education credits that you need for your HOA board. So, you guys did such a great job. I'm not even sure what's left to say other than my name is Danielle Brennan. I am a board certified specialist in condominium and plan development law
One of the
here.
few in the state, by the way.
Oh yeah, yeah. Thank you. Um, one of the handful in the state and one of nine here with Kay Bender Rambam. As Jeff mentioned, I work out of the Palm Beach Gardens office, but we do have other office locations throughout the state of Florida. We have our main office down in Pompano Beach, in Broward. We have Tampa, Winter Springs, and we do offer some office space in Miami-Dade by appointment. We provide expert legal services for community associations throughout the state of Florida. This is all we do day in, day out. There is, probably not an issue for a community association that comes across our desk that we don't have experience in. So, we've been doing it for a long time. I personally have been here with K Bender Rembomb for 13 years. And I'm a board certified specialist. And what that means essentially is that I've been doing it for a long time. I've gone through a peer review process and I've sat for an exam, which is essentially like a bar exam, but something that's focused for this area of law. I've recently had to go through recertification, which means that I did that process again, except I didn't have to sit for the exam, thankfully. So we do every matter of community association representation, be it amending your governing documents, doing full-blown amended restated governing documents, contract review, negotiation, violation letters, collection foreclosure, and violation litigation as well. So soup to nuts for your community association. If you have an attorney, you're happy with that attorney, obviously stay with that attorney. You can certainly get a second opinion on something, or if you're looking for somebody to provide legal services for your association, keep K Bender Rembom in mind. We do have a lot of free resources on our website as well at kbrlegal.com, be it Legal Morsels or Rembomb's Association Roundup. And we host classes like this all the time. You can go onto our website. We have a calendar of events where you can see what's coming next and register. So let me go ahead and jump into the presentation.
Go ahead and share that. And while Danielle's getting the slides up on the screen, put you all at ease. If you're in your pajamas or not wearing an article of clothing, no worries. I had a couple of people asking, can you see us? No, we are the only ones that could be
No.
seen and heard, so no worries about that today. And if you had issues signing on and you came in a little bit late, no worries. We're about to get to the first slide right now, which is also why we do a lot of talking at the beginning. We want to get you certified. We want to make sure you get your certificates. So we kind of air this out in the beginning to give people time to sign in. So we are good to go. Lou, Rodney, don't worry about it. You're right on time. Danielle, take it away.
Okay, no. So today's course is going to be focused on HOA, financial literacy, and transparency. If you've taken our HOA board certification course before, a lot of this material is going to be recognizable to you because it essentially takes everything that would concern dollar bills and puts it into one nice little package for you. So let's go ahead and get started. Here's some information about me, a photo of me when I was bright and bushy-tailed 13 years ago. So you can get more information about me and about our firm on kabrlegal.com. So jumping right into the meat and potatoes of today's presentation, let's talk a little bit about board compensation, kickbacks, and conflict of interest. So this section is focused on the director more so than it is on the association. So as you know, being a director or officer or committee member of your association, the pay is fantastic, right? Well, maybe not so much, because you're not entitled to receive a salary or compensation from the association for serving as a director, officer, or committee member. And you can't receive any other benefit that's not going to be a benefit that's provided to all other owners, such as insurance benefits, or if there's some kind of financial program that is for the benefit of all members. You can get reimbursement for out-of-pocket expenses so long as they're incurred on behalf of the association and subject to whatever approval procedures you have. Maybe it's something that has to be pre-approved by the board before you can actually make the expenditure and receive the reimbursement. Maybe there's some kind of litigation that the association was involved in and there was a windfall to the association. Maybe there's monies that could be divvied out. If it's something that's being provided to all the membership, then it's something that the director can receive, but it's as a part of being a member, not necessarily because of their role on the board. Now, the kickback prohibition is fairly new to the statute, although the concept has always been there. An officer, director, or manager cannot solicit, offer to accept, or accept a kickback. And a kickback is anything or service of value for which consideration has not been provided for an officer's, director's, or manager's benefit, or for a benefit of their immediate family member from any person who's providing or proposing to provide goods or services to the association. So it's a big. An officer, director, or manager who knowingly violates this prohibition commits a third-degree felony and is subject to monetary damages. So yeah, there are criminal charges that tied to receiving or offering to accept or soliciting a kickback. If an officer or director violates this prohibition, they're also removed from office by the board, creating a vacancy that gets then filled in accordance with law to the end of that term of service. However, an officer, director, or manager can accept food that's going to be consumed at a business meeting with a value of less than $25 per individual, which we oftentimes refer to as the McDonald's rule, because who can get a real meal at a sit-down restaurant for $25 these days, given prices of everything? Or you can receive a good or service in connection with a trade fair or education program. We do all sorts of these trade fairs, expos, what have you, throughout the state all the time. We just did one in Orlando that Jeff was at. We had another one in Palm Beach County, and before that in Broward County, where you go around, you receive your little squish balls or pens, pads, candy. Certainly any of those things that you receive at the trade fairs is fair game without having to be concerned about a kickback prohibition.
Can I just ask one question before you go to the next
Yes.
page so they understand two things? Some of the prizes that are given out at the seminars that are held are more than $25 in value. And I just want to confirm that that's not a problem. Like, they do a prize drawing at the end. so they
That's
understand
not a
in that
problem.
instance that's not a
Yeah,
problem.
the dollar figure is for food. It's not for like prizes that you may receive through a raffle or something. That would be under whatever goods or services you receive from that trade show program. That's not going to be considered a kickback. Even though they're there advertising their services, they're not providing you the TV or the iPad or whatever it is that you're winning through that raffle in exchange for a contract with the association. So it's not going to be something that's considered a kickback pursuant to statute.
The second question, I've had board members who have come back to managers and meetings or their fellow board members, and they have a relative, whether it's a son or daughter or a cousin, and they may do painting, they may do accounting, they may do services, and they want them to bid on a project that we're doing, and they disclose it to the board to tell them they're related to me in some way. Are they allowed to do that, Danielle?
So that's a conflict of interest
Hmm.
issue potentially. But we'll talk about conflicts of interest
Perfect.
next. That'll
Okay.
answer your question because it's really when it's a family member like that for an HOA, it's not really a conflict of interest as it would be in like a condominium situation. Anyway, we'll talk about that.
Okay.
So also when they added in the provisions regarding kickbacks, they did add in issues which would result in an immediate removal of a director or an officer. A lot of them having to do with associations funds or the election process. And this was as a result of a large case that happened down in Miami-Dade. So a lot of times the legislation that gets put into effect is reactive to something that's happening in real time. So this is something that was added as a result of that. A director or officer that's charged by information or indictment with any of these following crimes must be removed from office, such as forgery of a ballot envelope or voting certificate that's used in an election, theft or embezzlement of association funds or property, tampering with physical evidence, which could mean destruction of or refusal to timely allow inspection or copying of the association's official records in the furtherance of a crime, obstruction of justice, or any other criminal violation that may be provided in the Homeowners Association Act, which is Chapter 720 of the Florida statutes. If there is an instance which would result in immediate removal, the board does have to fill the vacancy, and that filling of the vacancy lasts to the end of the period of suspension or the end of the director's term, whichever occurs first. If their charges are resolved without a finding of guilt or without a acceptance of a plea of guilty or nolo contendere just meaning no contest, the director or officer is then reinstated for the remainder of the term. If the criminal charge is pending, then the person cannot be appointed or elected to serve as an officer or director of any association, not just the association of which they were on the board, and cannot have access to the official records of any association unless there's a court order providing that access. A director who becomes more than 90 days delinquent in the payment of any fee, fine, or monetary obligation to the association is deemed to have abandoned their seat on the board. A vacancy is created and then is filled according to law. This is something similar, you're hearing the more than 90 days delinquent. If that's ringing your bells in your mind, that's because that's the same standard that's used for the imposition of use right suspension and voting right suspensions for your members. It's more than 90 days, not on the 90th day, on the 91st day, this becomes effective. So for our conflict of interest disclosures, this is coming to what Marita was asking about earlier. Directors and officers must disclose to the association any activity that can reasonably be construed to be a conflict of interest at least 14 days before voting on that issue or entering into the contract that's subject to the conflict. A rebuttable presumption of conflict of interest exists if any of these items occur without prior disclosure to the association. A director or officer or relative of a director or officer enters into a contract for goods or services with the association, or a director or officer or relative of that director or officer holds an interest in a corporation, LLC, partnership, LLP, or other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. The statute doesn't define the term relative for the purposes of this section. There is some corollary to the Condominium Act, which referred to the third degree of consanguinity. Um, so we kind of use that as a rule of thumb. But to Marita's point is that if you have a disclosure, there's no presumption of a conflict of interest. So long as you're providing that prior disclosure, it's not going to be of issue. You certainly want to be having that disclosure. I would put it in writing and have it entered into the minutes when the board is approving whatever that contract is going to be. Now, this particular slide that we're going to talk about is pulled from chapter 617. Our Florida homeowners associations, for the most part, I would say 99.9% of the time, are formed as Florida corporations, not for profit, under chapter 617 of the Florida statutes. So, being that we are still corporations, we do have to comply with the requirements of chapter 617 when it comes to conflicts of interest, although for most of what we concern ourselves as homeowners associations, we're usually referring to chapter 720 of the Florida statutes. But in this instance, chapter 617 does provide us with guidance and requirements that we have to have that comply with when it comes to conflicts of interest for our directors or any corporation or entity in which the director is also a director or officer or is financially interested. So here we're really focusing in on the relationship of the director. So if it checks either of those boxes, then the board must comply with these requirements. They have to have the proposed contract fully disclosed to the board and that relationship entered into the minutes of the board meeting at which the proposed contract will be considered and voted on, and it has to be approved by 2/3 of the directors present. That contract has to be reasonable and fair to the association, and at the next regular or special members meeting, the existence of that contract with the director must be disclosed to the membership. The members can then motion to cancel that contract by a majority vote of the members present at that meeting. Now, if the members vote to cancel the contract, the association is only going to be liable for whatever goods or services have been provided up to the time of cancellation. And if there happened to be a termination fee, liquidated damages, or other penalty provided in that contract for cancellation, none of that's going to apply if the members vote to cancel that contract. All right, turning now to our official records. Now, there is a long list in Chapter 720 of what constitutes official records of the association. So this list that you'll see in this slide, or that I'll speak about next for those who are on the telephone, this is not an exhaustive list. Obviously, there are a lot of other records that are required to be maintained by the association as official records. But like I said, these are the items that are focusing merely on the dollar bills and financials for the association. So a copy of all contracts to which the association is a party, obviously part of the association's official records. Bids that are received for work to be performed also have to be kept by the association. Here we're mentioning that it has to be kept for at least 1 year. There are different times that official records have to be kept. Generally speaking, all official records have to be kept for at least 7 years. But bids, you're allowed to dispose of them after a year. Obviously, you want to be adopting a policy. You have to adopt a policy as a HOA regarding retention of your records. So that was something that was added into the statute. I believe it was through last legislative session. As a homeowners association, you must adopt a policy regarding records retention. So for those bids, you only have to keep them for a year. Financial and accounting records have to be kept according to good accounting practices. These records have to be maintained for at least 7 years. accurate, itemized, and detailed records of all receipts and expenditures, a current account and a periodic statement of the amount for each member. You have to provide the name, current address, the member, the date and amount each assessment or other charge of the member is due, how much they've paid when they make the payment, and the balance due. So this is essentially their ledger, right? All tax returns, financial statements, and financial reports, and we'll go over what these financial reports are later in the presentation, and any other records that identify, measure, record, or communicate financial information. Again, this list is not exhaustive. All of the written records of these pertaining to the association's business are official records of the association. As I mentioned before, at least 7 years, bids at least 1 year, and the association must adopt rules governing how they retain their official records. Now, although official records must be maintained by the association, not every single record is accessible to members through a request to inspect and copy the association's official records. So those records that are protected by the attorney-client or work product privilege are not accessible. Any information obtained in connection with the approval of a lease, sale, or other transfer of a parcel, assuming your association has that authority provided in their governing documents, you're probably getting some kind of credit check or background check. Those documents, although official records of the association, are not accessible to members. Information obtained in a gated community in connection with guest visits to owners or residents. I jokingly refer to this as the mistress provision. You're not entitled to that information. I see, Marita, I see that little smile. So any personal identifying information, social security numbers, driver license numbers, credit card numbers, email addresses, telephone numbers, fax numbers, emergency contact information, or any other address other than that as provided for association notice requirements. You cannot disclose that information. You can have a directory that provides the name, lot designation, mailing address, property address. So the association can put together that directory. The association is not going to be liable for disclosure of protected information if the information is included in an official record and is voluntarily provided by the owner, not requested by the association. So, the association usually does have some kind of protection for disclosure. However, any director who knowingly, willfully, and repeatedly, meaning 2 or more violations in a 12-month period, I thought they removed the repeatedly. We need to update this slide. Fails to provide access to the official records within the intent of causing harm to the association or one or more of its members commits a second-degree misdemeanor. So you certainly want to be providing timely access to the association's official records. Now that a bunch of official records have to be posted on a website for those associations who have 100 or more parcels, responding to these requests has become a lot easier for those associations. But if your association doesn't have 100 or more parcels, I would still suggest getting a website put together. I know Lang has some services that they provide for getting documents, correct, Marita?
Yes, and we also, when we get an official records request, and it is information that's on Vanica that our owners have access to, we do refer them back to Vanica. Like there is no coming in and looking through the records and asking for copies because we've made it available so that owners can see it and it's firsthand. So
Right, and
we
makes it so
do
much
that
easier.
no matter what size the association is. We are posting the information. Again, it makes it easier for the resident. There's nothing to hide. The resident can see it, and it saves the time of the staff, and the board for somebody on a records request.
Yeah, absolutely. Any person who knowingly and intentionally defaces or destroys accounting records during the period which those records are required to be maintained, or who knowingly or intentionally fails to create or maintain accounting records that are required to be created or maintained with the intent of causing harm to the association or one or more of its members commits a first-degree misdemeanor. Finally, any person who willfully and knowingly refuses to release or otherwise produce association records, excuse me, with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such avoidance, escape, commits a third-degree felony. I had mentioned earlier about the website requirement, associations having 100 or more parcels. Parcels is the word that's used in Chapter 720, but we usually refer to them as lots because that's usually how the governing documents define the residential pieces of land. With 100 or more lots, you must have a website or downloadable mobile application for the posting of the association's documents. Here's a list of those documents that must be posted on the association's website. Certainly your governing documents, including your declaration, articles of incorporation, bylaws, and all amendments to those, a copy of the current rules of the association, a list of all current executory contracts or documents which the association is a party or in which the association or the owners have an obligation. After the bidding for those contracts has closed, then you must also post a list of bids received by the association within the past year. You have to post your annual budget and any proposed budget to be considered at the annual meeting. I think it's a little bit odd for the statute to have provided for the posting of a proposed budget to be considered at the annual meeting, because typically, for the most part, I would say, again, 99.9% of our associations, the annual budget is being adopted by the board at a board budget meeting. It's not going to be voted on by the members at a membership meeting, which is what that annual meeting is. So it's a little strange for that to be there, but just my 2 cents. The financial report and any monthly invoice and income or any monthly income or expense statement to be considered at a meeting. The association's current insurance policies and the certification of each director. Again, that list is not exhaustive. There are other things that have to be on there. There is some more information about what that is here. Contracts regarding conflicts of interest, certainly notices. I won't dive into all of that because I'm already nearly halfway through and not halfway through the slides. So now about budgets and reserves. The association has to prepare an annual budget that would reflect the estimated revenues and expenses for the association for that upcoming fiscal year, and whatever estimated surplus or deficit they may have as of the current fiscal year. So that surplus or that deficit gets carried over, and then you anticipate, what your annual budget, what your annual expenses are going to be for the next year. Your fiscal year, usually it's January 1st to December 31st for a lot of our associations. However, you want to go ahead and look at typically your bylaws to determine when your fiscal year is for your association. Sometimes that fiscal year can be changed by the board. It just depends on what your bylaws provide for. The budget has to separately set out all fees or charges that are paid by the association for recreational amenities, whether they're owned by the association, the developer, or another person. That's only if you're actually paying those charges. If your association owns the clubhouse and is part of the common area, that's already going to be part and parcel of what your common area maintenance expenses are. And the budget has to include 2 main components: your operating expenses and your reserves, if you have any reserves. Now, for a homeowners association, reserves are very different than a condominium association. So if you hear conversation about condominium association reserves, it has nothing to do with homeowners association reserves. Reserves for a homeowners association, if they haven't been voted upon and created by the membership, they're not truly reserves, meaning they're not required to be funded in a particular calculation, and they're not protected, meaning that they don't have to be spent on only that particular reserve item. So reserves that are created in any way other than with membership approval are essentially slush funds or piggy banks that the board can ultimately use on discretionary items, notwithstanding the creation of a particular reserve. When coming up with your numbers for next fiscal year, obviously going to be looking at your actual expenses for this current fiscal year, monies that are in your operating section of your budget, even though they're maybe line itemed, they don't have to be spent on that particular item. So let's say you've spent less on legal than you anticipated, but you need more because, oh, we need to remulch everything. You can use the money in your operating for different items, notwithstanding that they were part of some other line item. For operating expenses, these are going to be the categories of income and expenses that relate to your day-to-day operation of the community and the association. You're going to have them listed by account and classification, and then in your line, you usually have what your actual was of last year and what your expected of next year is going to be. Examples could include administrative and maintenance, management fees, maintenance and repair of the common areas, taxes if you have to pay taxes, insurance, professional fees like accountant and legal fees, your landscaping, things like that would be included in there. For our reserves, I know I talked about this a little bit, got a little ahead of myself, but in addition to operating expenses, your budget may include reserve accounts for capital expenditures and deferred maintenance. A capital expenditure is any expense that is for the purchase or replacement of an asset which has a useful life of greater than 1 year, or you're making a repair to an asset that will extend the useful life of that asset for a period of greater than 1 year. Deferred maintenance is any maintenance or repair that will be performed less frequently than yearly and will result in maintaining the useful life of an asset. Examples could include pavement resurfacing, repairs or improvements to the common area, the association property, or common facilities. Maybe you guys have a pool and you need to do a pool resurfacing every however long that needs to be done. That could be something that you would include there. And sidewalk improvements. As I mentioned before, reserves that are true reserves are voted on by the membership upon the affirmative approval of a majority of the total voting interests of the association. Once it's approved by the membership, then the board must include that reserve account in the budget for the next fiscal year following the year in which the vote was taken and for each year following. Once it's established, then statutory reserve accounts have to be funded, maintained, or waived in the manner provided in Chapter 720 of the Florida statutes. Again, this is the only way to have a true reserve is to have it voted on by the membership. Then it's subject to the funding requirements pursuant to statute. Otherwise, it's just funds that are set aside for the association. For our true reserves, the amount that's reserved is based upon the estimated remaining useful life of the asset and the estimated replacement cost or deferred maintenance expense for that item. Now, the association can adjust the reserve assessments annually to take into account any changes in maybe the useful life of something. Maybe they've done some kind of repair or maintenance to it that extends that useful life. You can certainly take into account those changes in your reserve funding analysis. Funding formulas for statutory reserves have to be based on a separate analysis of each of the required assets, or if you have pooled reserves, then you can have a pooled analysis of whatever assets are in that pool. Unless you're maintaining a pooled reserve, the reserve schedule has to include each reserve account for capital expenditures and deferred maintenance or replacement as a separate line item, having the total estimated useful life of the asset, the estimated remaining useful life of the asset, estimated replacement cost or deferred maintenance expense, and the estimated fund balance as of the beginning of the period for which the budget will be in effect. Going from a straight line into a pooled reserve uses the same function as having a straight line reserve and then using that money for some other purpose. So reserve funds, once they're put into the reserve, they have to be used for that reserve item. However, you can use that that money for some other purpose if it's approved in advance by a majority of the members at a meeting at which a quorum is present. The same vote would apply when you're pooling your funds as well, because essentially what you're doing is you're taking two or more assets, putting them into this pool, but having one purse of money for all these different assets. So the dollar bills aren't particularly earmarked for one item or another, hence why we use that same vote in order to create the pool. Now, the difference between an individual reserve account and a pooled account is that instead of each individual item having its own fund balance that can only be used for that item, the money in the pool is available for costs affiliated with all of those items in that pool. So generally, it makes the reserve funding requirement on an annual basis a little bit less than what would otherwise be required for straight line or individual pool or individual reserve items. Once a statutory reserve account's been created, then the proposed budget has to include that item and it has to be fully funded unless otherwise approved by a majority of the voting interests of the members. And they can either waive, reduce, or terminate funding for that particular reserve. Now, if they're voting to waive or reduce a particular reserve item, that vote is only going to be applicable for the budget year. And whether or not to make that decision is something that's determined by the board. The board can either say, okay, yes, we want to present them with the option to do this or not. Reserve accounts that are created pursuant to statutes can then be terminated upon a vote of a majority vote of the total voting interest of the association. And once that is obtained, then the reserve account has to be removed from the budget. Now, going back to our general budget adoption, the governing documents really do need to be reviewed for any specific budget meeting notice and adoption requirements, because the Homeowners Association Act really doesn't talk about the specifics. Again, very different from a condominium. Some governing documents will require that a copy of the proposed annual budget be provided to the members 30 days prior to the budget meeting, the board's budget meeting. Some of them are completely silent. If the governing documents are silent, then the notice of the board meeting at which that proposed budget will be considered and adopted has to be conspicuously posted in the community at least 48 hours before the meeting. Now, if you are one of those associations that has 100 or more lots and you have to have a website, then you also need to be posting on that website notice of the board meeting and a copy of that proposed budget as well. As I mentioned before, unless your governing documents require the board to provide a copy of the proposed budget to the owners before that board's budget meeting, you're not required to do so, but you might consider doing so anyway. Once the budget's been adopted, then the association has to provide each member with a copy of the budget or written notice that a copy of the budget is available upon request at no charge to the member. Again, if you have 100 or more parcels, you are posting that annual budget on your website. If they do request a copy of the budget, then you have to provide them with that copy within 10 business days after receipt of the written request, which is similar to what you would need to do in order to comply with an official records request. So now that we've adopted our budget, we've essentially adopted what will be our maintenance assessments, regular assessments, quarterly assessments, monthly assessments, whatever your association refers to it as. Your general regular assessments are established by the adoption of your annual budget. However, we are aware that associations may need additional funds for different things throughout the year. Well, the way that we raise those typically is through a special assessment. You certainly want to be looking at your governing documents to determine your authority, the association's authority to adopt special assessments. Sometimes they can be adopted by the board without the need to obtain membership approval. Other times you may need to to get membership approval for your special assessment. So this is something that's really going to be governing document specific. If you have that
And and
authority,
and just and just to add in there, Danielle, because a lot of times the documents now are adding a dollar amount that they will allow the board on a special assessment. So from the board members, or the managers, you want to make sure there's not a dollar amount that you're prohibited to
right,
spend over that a board can approve on a special assessment.
right. And sometimes in the older governing documents, a lot of these provisions appear in bylaws as opposed to in the declaration. Really, the preferred area is to have everything in the declaration because the declaration is essentially like your constitution. It takes paramount precedent over every other governing document of your association. So, newer governing documents and amendments to governing documents pertaining to assessments, that's going to be in your declaration. But the older documents, a lot of this is in your bylaws. So you really need to be looking at your governing documents to see where these little nuggets are hidden. And sometimes it may not necessarily be an issue where you need to obtain approval to levy the special assessment. Sometimes it's, as Marita said, when you're actually spending the money. Sometimes you need to get approval just to make an expenditure of money. So things can be a little tricky, and you may want to have your governing documents reviewed by your attorney to provide you with some kind of opinion that you can stand behind as a shield when you're making these large expenditures. Anyway, so look at your governing documents, make sure you have the proper authority. If it is something that the board can levy, written notice of the board meeting at which that special assessment will be considered has to be mailed, delivered, or electronically translated to the members and conspicuously posted on the property at least 14 days before the meeting. Again, if you have 100 or more parcels, you need to post that as well on the website. In order to use electronic transmission for a means of providing notice, you do also need consent from your member to do that. Notice of that meeting must include a statement that the special assessment will be considered and include the nature of the assessment and should identify the estimated cost of the assessment. Although, the statute doesn't really say that. For a condo, it does. For an HOA, it doesn't. But certainly something that you should be including anyway. Once that special assessment is levied, then the association should send written notice to the owners of the special assessment and allow them a reasonable period of time to pay the special assessment. A lot of times, governing documents will say you have to provide notice at least 30 days prior to the assessment being due. So obviously something you need to be looking at your governing documents for, usually in the declaration or the bylaws. A special assessment that's not been paid by an owner is going to be collected in the same exact manner as a regular general assessment by lien or foreclosure process. So look at your governing documents, please, for your special assessment authority. This is a new requirement to provide an accounting that was added in by the July 1st, 2024 legislation. An owner can make a written request to the board for a detailed accounting of any amounts that they owe to the association that's related to their lot. And the board must provide that information within 15 business days after receipt of the written request. Once the owner makes the request to the board, they cannot make another request for at least 90 calendar days. If the board fails to respond within that 15 business day period, then that constitutes a complete waiver of any outstanding fines of the person who requested the accounting, which are more than 30 days past due, and for which the association has not given prior written notice of the imposition of the fines. So certainly you want to ensure that you're timely responding to these requests. If you have a management company like Lang on board, they have these ledgers available and can respond to these requests timely. So this is when having a good management company really counts. For our collection of assessments, people do get behind. It happens from time to time. Assessments that are not paid when due will bear interest at the rate that's provided in the declaration or the bylaws, but if there's no rate provided, then it's 18% per year. Notwithstanding whatever the declaration or the bylaws provide, compound interest cannot accrue on assessment and installment on assessments that are not paid when due. So we're not putting interest on interest. An administrative late fee, not to exceed the greater of $25 or 5% of the installment, can be imposed by the board if it's permitted by the declaration or the bylaws. Again, we're not charging interest on late fees. The association is going to be entitled to collect their attorney fees and costs that are incurred in collection for any delinquent assessments, but there is a small caveat to this with our notice of late assessments, which we will discuss. When we get that check in, we need to determine, okay, what do we apply this money to first? So statute helps us out here. Any payment that's received by the association has to be applied first to any interest accrued by the association, then to any administrative late fee, then to reasonable attorney's fees and costs, and then to the delinquent assessment. So you really aren't getting to the heart of the issue until the very end. Now, our notice of late assessment, as I mentioned before, with regard to the collectability of attorney's fees and costs. This was added to the legislation, I don't know, a handful of years ago. The association cannot require the payment of attorney's fees that are related to past due assessments without first delivering written notice of late assessment to the owner, which specifies the amount owed to the association and provides the owner with 30 days to pay that amount without the assessment of attorney's fees. Now, the statute does provide a form or the language to be used for the notice of late assessment, so certainly be looking up the statute in order to get that information. The notice of late assessment has to be sent by first class US mail to the owner at your last mailing address as reflected in the association's official records. And if that address is not the lot address, then you also have to send it to the lot address. Notice is deemed to have been delivered once it's put into the mail. And you also need to be doing an affidavit from the person who sent the NOLA notice of late assessment, either a board member, officer, or agent of the association, licensed manager, will provide a sworn affidavit saying, hey, we've gone ahead and we put this in the mail to this address being the last address or the parcel address, depending upon whatever's applicable. So you want to have that affidavit in hand. And certainly if you have to proceed with an attorney to collect the funds, the attorney is going to want to see that affidavit, both a copy of the notice of late assessment and the affidavit. Let's assume you've sent that NOLA out. They didn't pay. Now we're sending it over to collections, and the association's attorney is going to send out that first notice. So that first notice is going to be a notice of intent to file a claim of lien. It essentially says to the owner, hey, you haven't paid any of this stuff. If it's not paid within 45 days, the association is going to file a claim of lien. You send out that notice. They don't pay, 45 days have passed, then the attorney is going to record a claim of lien in the official records of wherever that lot is located. And then they're going to send out a notice of intent to foreclose. Now, the notice of intent to foreclose is another 45-day notice that says, hey, we've recorded a claim of lien against your property for unpaid assessments. If you don't pay up, we're going to file a foreclosure action against your lot. So let's say they went ahead, they didn't pay anything. Now we're filing a foreclosure action. We've got a lis pendens that's against their property. But there's also a first mortgagee out there. And if they're not paying their association assessments, usually the likelihood is pretty good that they're also not paying their mortgage. Let's say first mortgagee comes in, does a foreclosure action. And the first mortgagee or their successor in assignee obtains title to that lot by their foreclosure, by deed in lieu of that foreclosure. But there are assessments due to the association. Well, because of this particular statute, there is a safe harbor that's provided to them with regard to their liability for those past due assessments. So that first mortgagee or the successor in assignee who now has title of that lot is going to become liable for the lesser of either the unpaid common expenses that accrued on that lot for the 12 months prior to obtaining title, for which a full payment has not been made, or 1% of the original mortgage debt. So whatever's less is what's going to be due to the association, notwithstanding whatever actual amounts are due to the association. Now, this protection for first mortgagee liability for assessments to the association is only going to apply if that first mortgagee initially joined the association as a defendant in the foreclosure action. Um, they really don't make that mistake, typically speaking. So you're going to be looking at the safe harbor. I want to also mention that you really need to be looking at your governing documents as well. Even though the statutory safe harbor is provided, your governing documents might provide the mortgagee with a full forgiveness of whatever the past due assessments are for your association. So first look to the governing documents, because there is some case law on that as well. Now, let's say you've gone through the foreclosure, you're at the steps of the courthouse, and we are now bidding on the lot that's been in foreclosure. So third-party bidder on a foreclosure property has joint and several liability for any past due assessments. However, if the association foreclosed and obtained title to a lot, and then the lender foreclosed its interest, that third-party bidder is not going to be liable for the assessments that accrued during the time the association owned the property. So if the association owns the property at any point in time, whatever assessments accrue during that time are not going to be collectible. As I mentioned earlier, we were talking about some financial reports being official records of the association and having to be posted on a website. So what are those financial reports? Now, each year, the board has to prepare and complete or contract with the CPA for the preparation and completion of a financial report of the financial activities for the preceding fiscal year within 90 days after the end of the fiscal year, or annually on whatever date might be provided in your bylaws. Within 21 days after receiving that financial report or completing that financial report, but no later than 120 days after the end of the fiscal year, or other date that's provided in the bylaws. I feel like this was updated as well to 180, but I'll have to look. The board must provide each member with a copy of the financial report and written notice that a copy of that financial report is available upon request at no charge to the member. You just heard me say that I had to look to see if that was updated to 180 days. I might be confusing it with condominium because I just did the condo legal update. I do believe it is actually still 120 days for an HOA. Level of financial reporting. So whatever our revenues are as an association will determine how deep of a dive we have to do when creating our financial report. If we have less than $150,000, then we're having a cash receipt and expenditure report. 150,000, but less than 300,000, we're preparing compiled financial statements. If we have at least 300,000, but less than 500,000, we're preparing reviewed financial statements. And anything $500,000 or more, we're preparing audited financial statements. Now, I mentioned earlier about a particular case out of Miami-Dade. There were some legislative changes that were made as a result of that. This happens to be one of them. As of July 1st of 2024, regardless of whatever your total annual revenues are, if your association has at least 1,000 parcels, then you have to prepare audited financial statements. I can't imagine that an association having 1,000 or more lots would not have a large revenue, but this is what was added in by the legislation. Now, we know that there are particular levels for financial reporting, but we can change those levels. If 20% of the owners petition the board to have a higher level of financial reporting than what would otherwise be required, then the association must notice and hold a meeting of the members within 30 days of receipt of that petition for the purpose of voting on raising the reporting level. If it's approved by a majority of the total voting interest, then the association does have to prepare that higher level of financial report. A copy of the financial report must then be provided to the members within 90 days of the meeting or the end of the fiscal year, whichever is later. And the board must amend the budget or adopt a special assessment to pay for that financial report, regardless of whatever provision in your governing documents may be provided to the contrary. So let's say your governing documents do require some kind of membership approval for a special assessment. Well, if the special assessment is for the purpose of paying for audited financial statements because it was what the membership wanted, then the board can levy that special assessment without needing to get membership approval for it. Now, we can also lower that reporting level if it's been approved by a majority of the voting interest present at a properly called meeting of the association. Then that reporting level can be lowered. However, you cannot do that for consecutive fiscal years. So if you voted to lower it last year, you can't do it again this year. You do have to prepare that whatever level is required pursuant to statute. Now, in that financial report, you do have to make particular disclosures based upon whether you have reserves, statutory reserves, if they're fully funded or not funded. So this is something that's obviously you're having your CPA prepare your financial report. Generally speaking, they know of these requirements and will have these particular disclosures in your financial report. More so, this is being provided to you so that you know that they do need to be putting that in there for you. Now, contracts and bids, we did talk about this a little bit when it comes to conflict of interest and official records, but let's delve in a little bit deeper. Contracts have to be in writing if the contract cannot be fully performed within 1 year of the purchase or lease of the materials of equipment, or if it's a service type contract. In law school, we have this acronym, and I'm sure a lot of law schools do it, but it's called MyLegs. It's a statutory thing where these are the different types of contracts that have to be in writing. Obviously, even though only certain contracts must be in writing, I advise that all contracts be put into writing. It really is helpful for the association not only to hold the contractor or seller's feet to the fire, but also to show to the membership when the members are clamoring for some kind of backup documentation that the board acted in a particular way, which we see more and more, I feel like these days. So certainly you
And
want to have a
Danielle, just to add to that on what you want in writing, where we've found several times that an association will put out a bid specification for what they would like the contractor to provide, and then they do a contract, and it doesn't include all those specifications that they used for the bid. So we're recommending that people refer to that in the contract, that they're required not only to the contract, but to the specifications, the bid specifications that are attached to and made part of it. Because we've had contractors, unfortunately, come back to a board and say, that's not what my contract says. I mean, I understand that's what your bid said, but if it's not in the contract, it's really not enforceable. Correct?
Yeah, absolutely. I mean, particularly when it comes to larger projects, then you have engineers involved creating the RFP, and then you put the RFP out for bid and they're not putting it in their documents. I mean, that's poor business, I think.
Right.
And contractors trying to bamboozle boards. But that's when you have an association lawyer come in and review your contracts. And I mean, what's the saying? A pound of prevention or an ounce of
Mhm.
prevention. It really goes a long
Yeah.
way, particularly for your larger projects. Like, I don't
And
know,
all
the
large,
roof.
like landscaping, that's one of your biggest contracts. All of those should
Yeah.
be reviewed by the attorney, because we found too that someone might make a change to that is not even picked up on. Do you know what I mean? Whether it's the board or the manager and they miss it, and it's something that's picked up on the, by the attorney. So you should have the attorney review,
Right.
especially your larger contracts.
Yeah. Landscaping, sorry, Marita, but management contracts, those tend to be one of the larger ones. If you
Yeah.
have a club, if you have a guardhouse,
Mhm.
your quote unquote
Security.
security
Right.
contract, Those tend to be the largest dollar figures for an association that's incurred on an annual basis. So certainly something you want to be looking at, and making sure that you have, an attorney, look at your governing documents. As an attorney reviewing a contract, we typically don't look at the business aspects of it, like particular services or dollar bills that are involved, but we certainly look at the provisions that are there to protect the association in the event something goes wrong, like insurance, indemnification, termination, all of those provisions, how you settle disputes. Maybe they have a mediation requirement or an arbitration requirement in there. Those are the things that the attorney is really going to be focusing in on and honing in on. Because usually by the time the contracts come to us, all the business terms have been hammered out by the boards. Um, so they know what their deal is from a dollars and cents and services
Right.
side, but it's all the legal jargon afterward that we end up getting involved in. Excuse me. Okay. So bidding, we just talked about RFPs, and going out to bid and making sure that the specifications in your RFPs are going to be put into your contracts. Now, that process is part of our bidding process. Bidding is not always required pursuant to statute. However, I find that a lot of associations will put out to bid regardless because they want to get the best price for the work that's being provided. So, but statute does require that you go out for bidding if the aggregate cost of that contract is going to be more than 10% of your total annual budget, including reserves if you have reserves. Um, the association is not going to be required to accept the lowest bid, although that tends to be the case. So long as you're comparing apples to apples, I mean, why would you not, right? But just ensure that you're comparing apples to apples. The association is not required to obtain competitive bids if the products and services are being provided in emergency circumstances. Maybe there was hurricane damage, something like that. You're not going to be required to obtain competitive bids if you can even find contractors who are willing and able and available to do the work at that time. The association is not going to be required to obtain competitive bids for products or services, or when the business entity with which the association is negotiating is the only source within the county serving the association. And here, if you happen to have a contract that's executed before October 1st of 2004, and any renewal of that contract, they're not going to be subject to the competitive bid requirements. Why? It's because that's when the statute came into play. There are particular contracts, though, that are exempt from bidding requirements, like when you're hiring a particular person, the attorney, the accountant, the architect, your community association manager, although you could have a longer term community association management contract if it's done by competitive bid, your engineer and your landscape architect. Even though you don't need bids for these particular items, you do have to ensure that they are in writing. Again, these are service contracts, so they do have to be in writing. Now, a bit about our estoppel certificates. We've gone through the assessment process, and let's focus in on now on what happens when someone wants to sell their property and they have monies due. So within 10 business days of receiving a written or electronic request for an estoppel certificate from an owner or mortgagee or one of their designees, the association must issue an estoppel certificate. If the association has a website, they do need to designate on their website a person or entity with a street or email address who is responsible for receiving estoppel certificate requests. The estoppel certificate has to be prepared by a director, authorized agent, or authorized representative of the association, which could include someone from the management company. The estoppel certificate has to be provided by hand delivery, regular mail, or email on the date that it is issued. So the date that you're signing that estoppel certificate is the date that you need to issue it to the person who's requesting it. The estoppel certificate has to be signed by an officer or authorized agent of the association. Now, the statute does require that the estoppel certificate include certain information. This list is provided by statute. It's broken down into three categories: general information, assessment information, and other information. And it really focuses in on what monies are due to the association, what money will be due to the association, and are there any other fees that might be due to the association, like a capital contribution fee or a transfer fee. Also, it could provide for what violations might be existing on the property. For example, when I bought my home, which, a lot of association attorneys, you would think, oh, we deal with associations all the time. We would want to live in a home that's not an association. No, I went the opposite route. I live in a home that has two associations. So I had an estoppel certificate. Unfortunately, there were a couple of violations listed on there. So those were things that I had to take care of as soon as I moved into the property. I had to fix the mailbox, clean the driveway, things like that. So all of that information gets put onto an estoppel certificate. I'm looking at the time again, sorry, and I do want to get to questions. I know we don't have that much time left. So I'm not going to go through all of this list of items. Again, this is something that is going to be provided by statute. So you're going to make sure that you're putting in all this information about what assessments are due for that particular lot. And then the other information, those capital contribution fees, maybe there's like a transfer fee because they have to approve whoever's going to be purchasing the property. If there's information regarding insurance, you have to put it in there. If the person's in collections, then you would be putting the attorney's information. So look at all the information that is required for your estoppel certificate. Again, when you have a good management company, they're going to know what information has to be put in there. And usually, I think once we get in, a new management company, I feel like we get these requests all the time. They'll have us go through the governing documents to assist them with the preparation of the estoppel certificate so that they know, okay, this is where this information is found in the governing documents, so that these estoppel certificates become more like plug and play for the associations. Now, the fees that you can charge for estoppel certificates are governed by Florida statute. A reasonable fee not to exceed $250 can be charged if on the date that the certificate is issued, there's no delinquent amount due to the association for that lot. If there is a delinquency, then you can tack on another $150 fee. And if they ask for an expedited estoppel, you can charge an additional $100 fee, and you have to provide the estoppel certificate within 3 business days of the request. In order to charge an estoppel fee, the authority to do so has to be established by either a written resolution adopted by the board or as provided in a written management, bookkeeping, or maintenance contract. So a lot of times the ability to charge the estoppel certificate fee is provided in that management contract. If the association fails to deliver the estoppel certificate within that 10 business day period, then they cannot charge the fee for the preparation and delivery of the estoppel certificate. If the certificate is requested in conjunction with a sale or mortgage of a lot, but there's no closing that occurs and no later than 30 days after that closing date, the preparer receives a written request accompanied by reasonable documentation that the sale did not occur from the payor that's not the owner, the fee must be refunded to that payor within 30 days after receipt of the request. Estoppel certificates delivered by hand or by email are effective for 30 days. Estoppel certificates that are delivered by mail are effective for 35 days. I guess they tack in an additional 5 days to allow for the mail to catch up. If additional information or a mistake related to that estoppel certificate is found within that effective period, then the association has to issue an amended estoppel certificate, and that amended estoppel certificate gets the same effective period renewed. A fee cannot be charged for an amended estoppel certificate, and you want to be sure that whatever monies are being provided in that estoppel certificate are correct, because the association waives the right to collect any monies owed that are in excess of the amount specified in that estoppel certificate from any person who in good faith relies upon the estoppel certificate and from the person's successors and assigns. So you want to be sure that the dollars and bills that are provided in that estoppel certificate are correct. And that's all I have for you today.
Are you out of
Like I said, I
material?
want to be, yeah. Sorry. I mean, I could talk some more.
Well, I know you both want to get to some of the questions in the Q&A. There's a bunch of them. We won't get to all of them. There's about 15 minutes left. But before the ladies do that, what I'm going to do is just briefly remind everybody, if you haven't already done so, press the chat button so it appears, and we'll once again place the evaluation link in there. That's a required thing. We collect the info, and that's where we get the information we need to send you certificates or report CE credits for managers. So be sure you click on that link and fill out the evaluation. And after you do that, the screen after submitting it there'll be many links, including Marita's and Danielle's contact information, but also a link to download and save the slides after you fill out that evaluation and submit it. So press the chat button. I'll place the link in there again in just a moment. And I will now turn it back over to Marita and Danielle for a little bit of Q&A. And just one other thing, folks, we want you to hang out for the Q&A. You're welcome to. Please do. But after you submit the evaluation, the required part is over. You can go if you have to get out to another appointment. Ladies, back to you.
All right. So I'm looking through some of these questions here.
And folks, when you type in your questions, please keep it short, sweet, and not too specific to your association. We don't have your documents in front of us, and this is not to be considered as legal advice anyway.
I'm going to follow your lead if you need something from me on the questions,
Sure,
Daniel.
sure. Okay, so I'm looking at a question from Millie about a foreclosure, and then there was a roof assessment on the property. Home was obtained by auction. Then house was sold again within a few months. Okay, who's responsible for paying the roof assessment? So owners are jointly and severally liable for assessments that are due to the association. So if the assessment was made on a prior owner and then a new owner takes possession and obtains title, that will still be an obligation of the current owner. So you'd still be able to collect. Now, my only concern is that whose foreclosure was it and the timing of things. So you're going to want to look and make sure that it wasn't something that would be covered under a safe harbor issue if it was done prior to maybe the first mortgagee or successor or assignee obtaining title. But generally speaking, there's joint and several liability there. So you'd still be able to collect that roof assessment. But have it reviewed by your attorney to make sure that that's correct.
While Danielle's looking, I want to piggyback on something both Marita and Danielle stressed earlier. They were talking only about contracts, but I'm going to expand that for a second. Managers and board members should never be interpreting the law. It's one thing to quote the law and read what the law says, but you should never try to interpret it to make something work the way you want it to work for your association. Always contact your association counsel if you're not sure about something.
Okay, so there are a couple of questions related to bidding and using the same contractor or vendor when something's already been previously bid and awarded to that vendor. The statute doesn't care if it's the same contractor or vendor. If you are proposing to enter into an agreement for work or an item, the expense of which is more than 10% of the annual budget, including reserves, then you're still going to be subject to the bid requirements, notwithstanding that you have a standing relationship with a particular vendor or contractor.
And one of the questions was, do the records have to be paper or do electronic records suffice? And that's where I said to you, we keep them in Vanica so that we do have them available that people can see them electronically. But their question was, do they
Yeah.
also have to be kept in paper?
No, no, you don't have to keep them in paper as well. In fact, a lot of associations and the statute is moving more and more electronic. If you have records that are kept electronically, but they're not posted on a website, you could still have the person come in and review them on the association's computer or the manager's computer, if you want to provide them with that type of access. But you don't have to maintain physical paper records. I think the only, practical exception to that would be if you have original signatures to things. Although, typically for litigation purposes, electronic signature, like an electronic copy of an original signature, will suffice for evidentiary purposes. But it is always nice to keep original signatures to things. Again, though, it's
Yeah,
not
we're
something that's
trying to do
absolutely
everything
required.
electronically now to get rid of the
Yeah,
paper.
yeah, yeah. Um,
Um,
let's see here. What can you
Danielle, another
post on?
question. Does the entire insurance policy need to be posted on the website, or can just the insurance um, certificate listing all the policies and premiums suffice?
I would advise the entire policy be provided, because the statute doesn't state like a term sheet or something like that to suffice. Um, I would say better to over disclose on that than to under disclose. They're entitled to a copy of the policy, notwithstanding whatever the posting requirement is. Um, so I would be posting an entire copy of that insurance policy. Let me see here.
I have another question if you want me to read it while you're
Sure,
looking.
sure.
Okay, for the 90-day delinquent statute, who removes the board member? Is a board meeting needed to remove the delinquent director, or are they automatically removed and the vacancy can be filled?
It's automatic. It happens automatically, and the board can fill it at the next board meeting, or notice a special meeting in order to fill it. I think minimally what the association should do, management or someone else on the board, should send them a notice saying, hey, you're delinquent, and pursuant to the statute, you're automatically off the board, because you don't want them to be blindsided at the next board meeting and then you have it out in front of membership. So certainly, even though it's not required by statute, I would send them some kind of notice that they're not compliant.
I want to elaborate on something you touched upon earlier with insurance. When it comes to website requirements, I think the statute says a list of all contracts. Yet what I see happening is most people put the contracts themselves. Which is it? Is it, do you just need the list, or do you need a link
It's
where
a
somebody can click
list.
on it and see the contract?
So it's a list of all contracts, essentially. Executory contracts, meaning contracts that have been signed, or contracts under which the association or the members have some kind of obligation. Oh, only a list is required, not a copy of the contract. Now, whether or not a copy of the contract in lieu of providing a list suffices because you're providing more information, I wouldn't go that far. The statute does say list, so you should be creating a list of those contracts. Though certainly, if you wanted to, you could post a copy of that particular contract. Now, if the contract is something that would present a conflict of interest or potential conflict of interest, that copy of that contract does have to be posted, because there are different sections that refer to different contracts in that website posting requirement. So you do have to look at what the contents of that particular contract are in order to determine whether or not you have to post a copy. But if it's not one of those contracts where you have to post a copy of the contract, then it would be included in the list.
Okay. Thank
And
you.
then the
I know.
list would be posted.
I feel like we have you on Jeopardy right now. Is there,
That's okay.
is there,
You know what's funny? I was just watching like a whole thing of Jeopardy last night on Hulu as I was doing some Legos,
There you
because
go.
just that's my nerdiness right there.
I'll take
Yeah,
contracts for
I get it.
1,500, please.
Yeah,
Yes, yeah.
exactly, exactly.
Hey, you know what?
And
It's actually more entertaining for the people watching than to see me like this, like and reading the questions to try to find something.
yeah. Is there an amount of agenda and minutes of meetings that should be posted in the website? They're asking how far back do they have to post their agendas and their meeting minutes? Is it 1 year? Is it annually? How far back in time?
I don't think the statute addresses this
Right.
issue. Um, are you obviously if you have an upcoming meeting, you're posting that upcoming meeting. Um, it's a good question because if you've already had the meeting, the notice, presumably, I'm going to go out on a limb and say that if it's not for an upcoming meeting, you can probably remove it, but you do still have to post the minutes of that meeting. So if you've had the meeting, I would say you don't need to post the notice for that meeting, but obviously you do have to provide for the minutes for that meeting.
Yeah, we pretty much have always been under the understanding and posting as far back as we have meeting minutes. I mean, we have associations that we're with since the first shovel went in the ground, and whatever minutes that we have, they're posted by year and
And
we're
that's
saving
certainly the more
years. So
conservative approach. And obviously, you're
mhm.
not going to be, like I said, I'm usually in favor of more disclosure. But as far as what's required pursuant to law, if you want to be, a little bit riskier, but certainly more disclosure, providing more information on the website, making more stuff accessible to owners via the website is not going to hurt the association. So
Right,
long as the whatever's being posted doesn't have information which is not subject to disclosure, like the attorney-client privilege stuff, like the medical information from the owners, like things having personal identifying information. If something's got a social security number in it, and is not required to be posted on the association's website, don't post that information. Or if it
right.
is required to be posted on the website, you have to redact that information out. So obviously, without creating any kind of issue with improper disclosure, post away. Uh, you know,
We have a question on the reserve study. And actually, I was going to ask this when you were talking about the reserve study. If we're obligated to book the reserve amount shown on the report, and I'll give you an example. Some of the reserve studies, they list everything from the street lights to the sidewalks. I mean, things that are never going to be replaced in totality. Like sidewalks will be replaced if there's a repair. Do you know what I mean? Or a chip or something that needs to be done. But they list those and those dollar amounts, and there's communities that they do not reserve that. I'm specifically talking HOAs because the amount would be phenomenal for every
right.
single, piece that goes there. And we have someone asking, are they required if there's a report that comes out and it says, and I'm just throwing a number out, you have to reserve $1 million, but they go through it and say, well, wait, unless we had a hurricane that tore up the entire community or a tornado, you're never going to have to replace all your sidewalks. You're never going to have to replace, all the light poles. Once they do a reserve
Right.
study, are they required to reserve for that?
Short answer is no, unless you actually have a reserve for that item. So, like I mentioned before, for the HOAs, it's very different than in condominiums. HOAs are not required pursuant to statute to provide reserves. The only reserves that an HOA would be required to include in their budget are those that are established by the membership, by vote of the members. So if you have a reserve study done because you are required to have a reserve for road repaving, but they give you a litany of other things, you're not required to adopt those reserves. You would just be looking at that one particular item for which you are responsible to maintain a reserve account because the members have told you you have to reserve for that particular item. Now, could the board establish reserves for other items in a reserve study? Yeah,
Like a
sure.
general
But it's
reserve.
not that's just a general reserve. We call
Mhm.
them non-statutory reserves. And that's something that is discretionary created by the board. It's not something that's required pursuant to statute because it's been approved and adopted by the members. Um,
And we have time for a few more. It's up to you both. It's totally up
sure.
to you.
There's a question here that
So,
I'm gonna address because it's something that's near and dear to my heart, which is updating governing documents. It's something that I do all the time, all day, every day, amending
Now
and
we have a
restating
class
governing
just
documents.
for it.
Yeah, and I teach that one in my sleep. So, should you update your governing documents to meet Florida law? Well, it depends. Certainly, governing documents, when they're created, are created by the developer with the developer in mind. And so they have all kinds of rights in there pertaining to the developer. Like I was mentioning before about the safe harbor, usually developers will provide for a clean wipe of past due assessments for the mortgagee because they want mortgagees to issue mortgages on their property so they can sell them as fast as possible. Well, that may not be in line with what the association wants for itself because then they could be out thousands of dollars every single time a property goes into foreclosure. So you want to be looking at those issues and certainly want to be amending in the ability to have the statutory safe harbor if your association provides for a clean slate for those mortgagees. When it comes to certain rights like that, absolutely, I think it's beneficial to update your governing documents to meet Florida law. Another example, since we're talking about money, is with regard to fines. So the association's authority to fine is limited to $100 per fine and $1,000 in the aggregate, unless otherwise provided in your governing documents. So your governing documents can allow the association to levy a fine in an amount greater than $100 and an amount greater than $1,000 in the aggregate. Certainly something you want to be considering in adopting an amendment to your governing documents. But generally speaking, every year the statute changes, although an anomaly this past legislative session, really nothing was done. But every year the legislature likes to putz around with the Florida statutes governing community associations, more so lately governing condominium associations, although a few years ago, HOAs got socked pretty hard. So no, I don't think annually, you need to be updating your governing documents. I think what you really need to be considering is, what's affecting your community association? What's going on in your association that may need to be updated in your governing documents? And usually what I recommend to associations is to create a committee of your members. Have them go through it, have them make recommendations to the board about what they want to see in the governing documents, and then go from there with counsel and reviewing the governing documents, getting them up to snuff. I mean, for the most part, when it comes to your bylaws, that's going to be most affected by Florida statutes because those are procedural items, the how-tos of how do we hold a board meeting? How do we do this? How do we do that? Those procedural items usually get updated by Florida law. What is it? Oh, Star Trek.
Jeff's holding up the sign. We're out of
Hopefully
time.
don't. Sorry.
Jeff, you're muted. You're muted. We see you waving a sign, but you're muted,
Oh,
Jeff.
sorry. The reason I'm bringing this up, this is the scene. This is community association living in a nutshell, and exemplifies what Danielle was just explaining. Hang on.
Yeah, we
It's
can't see it, just so you know. It looks like
it's
you're
the it's
waving something, but we
yeah,
can't really
it's the
see it.
scene from Star Trek II: The Wrath of Khan, and Kirk Mr. Spock went into the dilithium chamber knowing it was certain death to save the Enterprise to get away quickly from a planet about to explode. And before he died, he told Captain Kirk the needs of the many outweigh the needs of the few or the one. And that is association living. I know that's a general statement, but that's association living in a nutshell. Like what seems like a great idea for one or two people may not be beneficial for the entire association. And that's essentially what Danielle and Marita were just talking about with regards to your documents, your rules and regs, how things
Everything.
happen. So if you haven't seen this movie, if you're a little young, on the younger side of things, this is a microcosm of community association living.
I really Jeff, I want to thank you and Danielle. As I said at the beginning, I truly appreciate that you have taken the time to do this for board members and property managers, and it's time out of your day that you're dedicating to give them their education. Again, at no cost. There's a lot of attorneys and places that are charging for these seminars, and we came to you and asked you to help our board members. We appreciate that and everyone else who attended today. So thank you both for this time. And again, there's another one at 2 o'clock today. So we hope to see you on that one as well.
Yeah, and
Is
it's an
anything you
important
want
one
to close
about
with, Danielle or
elections.
Jeff? Go ahead.
No, I'm just saying that the class this afternoon is very important for our HOAs because it's about elections, and I feel like there's a lot of homeowners associations out there who are doing their elections like a condominium style election,
Yeah.
but it's not actually in accordance with their governing documents. So super important class happening at 2 o'clock with my colleague here in our Palm Beach Gardens office, Peter Mullengarden, who is also a board certified specialist in condominium and plan development law and has been doing it a wee bit longer than I have.
Absolutely.
Well,
She's joking. He's
I'll
been
be
around.
sure to tell him,
Danielle
Jeff,
started, yeah, Danielle started when she was
that I
10.
worked.
Peter started when he was 15 or so. So it's like,
Well, I started with Lang 30, almost 33 years ago, and Peter was around then. So he's been around for a long time.
Yep. Yep. All right.
uh,
Well, thank you so much, Marita and Lang, and thank you, Jeff,
Thank you.
for always, nudging us to do classes.
thank you
Thank you.
for,
Hope to see everybody this afternoon.
thank you both. And you both have a wonderful day.